Hello, this is Kent Holland presenting the video version of the ConstructionRisk.com report, February 2013 issue. The first case that we're going to talk about today involves a condo association that was found to be barred by the Economic Loss Doctrine from suing the developer's consultant for repair costs. And what I'm going to actually do is just go ahead and put up a few slides that I prepared based on the articles. All of these articles, of course, are on the print version that you receive by electronic email, as I should call it an electronic version, and it's also on my website so you can go and read these articles. But this will be just a quick snapshot, try to keep it quick. So the first case involved the condo association. It settled for $7 million from its contractor for a cost of repairing construction defects that were caused by a contractor doing various apparently insufficient work that caused water penetration through the walls. Improper bracing of gables was involved. There was improper end walls, improperly supported trusses, unsupported bearing walls, and there were balcony problems. So the association tried to sue the consultant that had worked for the original project developer, who had been under contract to the developer to provide value engineering, construction feasibility studies, and consultation on the selection of materials and equipment. The court held that that action was barred by the Economic Loss Doctrine because it was a negligence claim. And there couldn't be a breach of warranty claim because there was no contract. They lacked privity of contract. So the court said no implied warranty was owed. So the court relied on the contract that barred third-party rights, and the way the contract read is as follows. The contract documents shall not be construed to create a contractual relationship of any kind between anyone other than the owner and the contractor. Close quote. So any potential implied warranties could not pass through to the association because there had to be some contractual privity before you would have the right to rely on a warranty. And the court also rejected a UCC warranty type claim that was made by the plaintiff because the court said, quote, "We're not here dealing with the sale of movable goods or indeed with any sale at all between the association and the consultant." Close quote. The court also rejected the association's argument that the consultant owed it a duty to use, quote, "professional care," close quote, in performing its services. The association had argued that the rule should not be applied to strip a plaintiff of its tort remedies if the plaintiff has no other recourse and the defendant owed the plaintiff a duty of care. Well, the court rejected that argument, rejected the argument that the consultant would have foreseen with reasonable certainty that the association would be an injured party by its failure to exercise reasonable care, or exercise reasonable care on the part of the consultant. And the court stated that the remedy for purely economic losses resulting from the reduced value or the cost of repairs of the construction defects sounds in contract rather than tort. So the court rejected the association argument that because it lacked a contractual basis to sue the consultant, it should be permitted to sue for negligence. So here, the Economic Loss Doctrine applies whether there's a contract or no contract. It still applies to these purely economic losses. No third-party duty was owed to the association. And one of the things the court looked at, of course, was the contract language that barred third-party beneficiaries. The next case deals with an engineer that was found to owe an independent duty to a contractor to provide specifications that would not cause delays and disruptions. When liquidated damages were assessed by an owner against a contractor for late completion, the contractor sued the project engineer, asserting that the delay was caused by defective plans and specifications, and the engineer misrepresented that the owner would waive the project schedule. The court rejected the engineer's argument that its representations were within the scope of contractual authority for its client, and therefore not able to be sued by a contractor. Now that seemed like a logical argument. The engineer says, look, my decisions concerning the project were all on behalf of my client, and you can't interrupt the way I work for my client by allowing this contractor to sue me for making the very decisions I was supposed to make for my client. Now, of course, there are a lot of other decisions that exactly hold that, and we've talked about those in previous newsletters. But this court said the contractor cannot sue based on the engineer's alleged breach of contract with the owner. However, the contractor may sue in tort for negligence for its losses that were allegedly caused by the engineer's defective work and alleged misrepresentations. Now, what the court said was the contractor wasn't suing for the defective work itself, it was suing for the losses caused by that defective work, and that somehow made the suit okay. It's interesting here that the case makes no mention of the Economic Loss Doctrine, at least by name. It doesn't even mention it. And apparently, the doctrine doesn't apply in Louisiana. This is the Lafourche Port versus James Construction case, Louisiana 2012. Next case is one that says that arbitration that resulted in a decision between an owner and a contractor has no collateral estoppel on a subsequent litigation with the architect. So in this case, the project owner lost the arbitration with the contractor and then filed suit against its architect to recover damages on the same project. And the trial court granted summary judgment to the architect based on collateral estoppel, barring the suit. But that was reversed on appeal, with the court holding that the doctrine only applies to preclude a party from relitigating an issue that's been clearly raised in the prior action or proceeding and that has been decided against that same party. And here the court found that the owner failed to show that the issues of negligence or breach of contract by the AE were actually litigated, squarely addressed, and specifically decided in the prior arbitration proceeding. The court found that the summary judgment was properly granted to the AE as to lost profits that were claimed by the owner. And this is separate apart from this decision saying that there's no collateral estoppel, but the court said the summary judgment was to be granted to the AE as to lost profits that were claimed by the owner because special and extraordinary damages were not recoverable because they were not natural and probable consequences of the breach. This is the case of Crystal Clear Development versus Devon Architects, 97 AD 3rd 617, New York 2012. The next case involves a subcontractor waiver of claims against the payment bond. And the court found that this kind of a waiver that takes place in the contract is void and unenforceable. So in this case, the subcontractor, by the very terms of its contract, waived the right to make a claim against the prime contractor's payment bond. And the court held that that waiver was contrary to public policy and therefore unenforceable. The statute required the general contractor to provide a payment and performance bond on this public project. The general contractor terminated the sub for default, and then the sub and the GC ended up in litigation with the sub suing the GC for breach of contract, and it prevailed in front of a jury. But the trial court granted the general contractor and its surety a directed verdict based on the sub's waiver of its bond right. So in other words, the sub recovered in a jury trial, but then on a directed verdict, the court said, well, that's fine, but you can't recover under your bonds. You've waived all your rights, and you can't go against the GC or the surety because of your waiver of bond rights. This was reversed on appeal by the court, saying that so contrary to public policy, you cannot waive these rights by contract in advance. Another aspect of that same case, and that case was called Costa versus Brait Builders, 972 Northeast 449, Massachusetts 2012. I've split that case into two different articles because they're so distinct in what the subject matter was that was considered. So the next article is the subcontractor waiver of consequential damages was enforced where the clause was flowed down from the prime contract with the owner. So this is interesting. There was an incorporation by reference clause in the subcontract that expressly incorporated the prime contract. And the prime contract had a waiver of consequential damages clause in it. Well, this is the same decision again that found that the waiver of bond rights was unenforceable, but it found that the waiver of consequential damages was enforceable. So here the general breach of contract damages were worth $199,000, but the jury also awarded $1.1 million total that included consequential and incidental damages. The court held only the actual damages could be recovered because the consequential damages had been waived by the contract. The court said, in general, flow-down clauses are acceptable and common as a method for general contractors to limit their risk. Now, note, it's really important when reviewing subcontracts to review the prime contract as well, because typically the subcontract is going to say that the prime is incorporated by reference. And you could negotiate a great subcontract with good limitation of liability provisions, waiver of consequential damages provisions, a good standard of care, only to find out that the prime contract trumps all that good language because it says that your prime contractor or designer has agreed to all kinds of onerous or uninsurable conditions that then get flowed down to you and take precedence, priority over your subcontract language. Very interesting. I will be talking about a case in next month's issue involving New York law, where under New York law, this case would have probably turned out quite differently, because under New York law, the terms like these do not flow down unless specifically said to do so. So when you see an incorporation by reference clause, it's rather limited as to what that means in New York. The next case is called Completed and Accepted Doctrine bars third-party suit against an AE that failed to report obvious construction defects to the owner-client. And here a theater patron filed a slip and fall suit against an architect, alleging that breach of contractual duty to its client occurred in that the AE failed to report that the contractor had not installed contrast marking stripes on these interior theater steps as required by the plans and specifications. Now, the architect failed to do a final observation and certification that the contractor had properly installed the striping. The court held that the absence of the striping was just so obvious that the owner must be charged with knowing that the striping wasn't installed. In other words, it was a patent absence. It wasn't something that the owner could only discover much later. It was obvious right now. And this constitutes acceptance by the owner of the work and shifts the liability to the owner. This case is called Neiman versus Leo Daly, 210 California App 4th, 962, 2012. The court explained the reasoning for that holding as follows, quote, when a contractor completes work that is accepted by the owner, the contractor is not liable to third parties injured as a result of the condition of the work, even if the contractor was negligent in performing the contract, unless the defect in the work was latent or concealed. The rationale for this doctrine is that an owner has a duty to inspect the work and ascertain its safety, and thus the owner's acceptance of the work shifts liability for its safety to the owner, provided that a reasonable inspection by the owner would disclose the defect. The last case we'll talk about here is Certificate of Merit. In the Texas case, the court held that the Certificate of Merit requirement was waived by the engineer's failure to timely push for dismissal. So what happened here was there is a Texas requirement that a plaintiff file a Certificate of Merit signed by an expert when it files a complaint against an engineer. In this case, the plaintiff didn't file that, and the AE filed a motion to dismiss the case for lack of that certificate. But nothing ever happened. The court just never acted on that motion. 3 years go by. The AE is going along, participating in discovery, filing interrogatories, doing depositions, filing motions, and gets about a month before trial and goes back to the court and says, hey, I really need you to decide this motion I filed 3 years ago to dismiss for failure to file a certificate. And the court looked at this and said, no, you've waived your right to have that certificate requirement enforced for the following reasons. The AE substantially participated in litigation for 3.5 years before asking the court to issue a decision on that previously filed motion. The AE forfeited its right to dismissal by resting on its rights for so long. And the AE demonstrated an intent to substantially invoke the judicial process and intended to relinquish his right to seek dismissal. I just make a note here as a litigator that this creates a perplexing question, because I've had situations where a plaintiff has failed to file a certificate, and I've intentionally waited until their deadline passes before I raise it. And you want to do that because in some states that is a fatal flaw. You can't come back in as a plaintiff and file a new suit. It's dismissed with prejudice. So now looking at this case, I'm wondering, how long should I wait? Do we just wait until the deadline's done? What if I'm tempted to do discovery before the deadline? Should I kind of hesitate doing that lest a court use this type of reasoning to say I was too happy to get involved in the litigation. I participated too readily in the litigation process. So it's just something to think about if you're defending a case. Thanks. Again, this is Kent Holland from Construction Risk LLC. I will put my contact information here on the last couple slides. This is an AIA registered course. You can actually view 3 of these together and you'll have a 1 credit hour course. So you're welcome to do that if you like. Thanks a lot. Look forward to being with you again.